Good afternoon and welcome to the House Criminal Justice Committee for Tuesday, April the 27th. Madam Clerk, please call the roll.
Representatives Beck, Campbell, Dixie, Doggett, Farmer, Griffey, Hardaway, Hawk, Howell, Holsey, Lamar, Lamberth, Moody, Russell, Sherrill, Vice Chairman Sexton, Chairman Curcio. Chairman, you have a quorum.
Thank you, Madam Clerk. Members, today will be what we hope will be our final meeting of the Criminal Justice Committee. We do have a full calendar today. Before we get started, does anybody have any personal orders? Seeing none, we will jump right in. The first item on our calendar is House Bill 1143 by Vice Chairman Grills. Sir, you're recognized. You have a motion and a second.
Thank you, Mr. Chairman. If you gave me this mic.
Yes, sir.
Okay. Do we have an amendment on this one?
Sir, the amendment that I have is coded 7538. Is that the one you wish to move today?
Let me see if I can. That is correct, sir.
All right. Sir, you have a motion and a second on your amendment. It makes the bill, so if you could, please describe the amendment.
Okay. House Bill 1143 as amended is a simple bill that increases the penalty when a person with a conviction for vehicular assault, aggravated vehicular assault, vehicular homicide, aggravated vehicular homicide, or driving while intoxicated is caught for a third time while driving with a canceled, suspended, or revoked license. This bill enhances the penalty from a slap on the wrist, Class A misdemeanor, to a Class C felony. To be clear, this bill only enhances the penalty because of the violent, dangerous action to the licensee already been convicted for.
Thank you very much for that explanation. Members, do you have any questions for the sponsor of the amendment? Seeing none, we're ready to vote. All those in favor of attaching amendment coded 7538 to House Bill 1143, please signify by saying aye. Those opposed, you adopt. Members, you've heard the explanation of the bill as amended. Any further questions? Seeing none, all those in favor of sending House Bill 1143 as amended to Finance, please signify by saying aye. Those opposed? Sir, you head to Finance.
Thank you, Chairman Curcio, for working with me on this as well. I know we had a couple of questions, and you were always great. I really appreciate that in committee.
Well, thank you. Appreciate your hard work on this. Yes, sir. Members, that brings us to item number 2 by Vice Chairman Wright. Sir, you have a motion and a second on House Bill 924. I do see an amendment. Do you wish to move an amendment today? I think you do. I have an amendment coded 6228.
Okay, thank you.
Makes the bill.
Thank you, Mr. Chairman.
Okay.
That's correct.
All right. Yes, sir. You have a motion and a second, and you are recognized. It makes the bill. So please just explain your amendment.
Thank you, Mr. Chairman and committee. What I'm here to present in this bill is authorizing law enforcement agencies to use drones in 3 additional ways. This is law enforcement requested, district attorney drafted, and then amended as we're looking at.
Would you say it's kid tested and mother approved? Sorry, you're recognized. It's okay. My jokes were funnier at the beginning of the year, but you weren't here then, so yeah, no.
Thank you.
Sir, we've had questions been called on your amendment. Without objection, we're ready to vote. All those in favor of attaching amendment coded 6228 to House Bill 924, please signify by saying aye. Those opposed, you adopt. Members, you've heard the explanation of the bill as amended. Do we have any further questions for the sponsor? Representative Dixie, you're recognized.
Can you just tell me you said it's going to be 3 additional ways that they're going to use it? Can you just tell me the 3 additional ways?
Yes.
Sir, you're recognized.
Yes. Thank you, Mr. Chairman. One of the new ways would be to investigate a crime scene, not while the crime is taking place, but the scene after a crime. A second way would be a natural disaster, a declared state of emergency. And the third way would be at large-scale events.
Representative Dixie, do you have follow-up?
No, when you say, I'm sorry. When you say large-scale events, what can you define that for me, or a little more clarity?
Yes, a little more clarity.
Representative Wright, you recognized.
Thank you, Mr. Chairman. A large-scale event would be something on public property where the event promoter would like to have enhanced security using drone.
Thank you. I'm fine with that explanation. Thank you, Mr. Chairman.
Question's been called on the bill. Without objection, we're ready to vote. All those in favor of sending House Bill 924 as amended to calendar and rules, please signify by saying aye. Those opposed? Sir, you had the calendar and rules.
Thank you, Mr. Chairman and committee.
Yes, sir. Thank you. Members, that brings us to item number 3, House Bill 733 by Representative Smith. Ma'am, you have a motion and a second. I also see an amendment coded 6819. Do you wish to move that today?
Yes, thank you kindly, Chairman. I would like a motion and a second on Amendment 68919, excuse me.
Ma'am, you have a motion and a second on your amendment. It looks like it makes the bill. Would you describe your amendment, please?
Yes, in current code 39-14212B, subsection 1, a aggravated cruelty to a domestic animal is defined as an act that is done or carried out in a depraved and sadistic manner. And this very subjective definition has added some layers of cost and delay to making a prosecution. So this bill and the amendment essentially redefines aggravated animal cruelty to be those acts very specifically that kills, maims, tortures, crushes, burns, drowns, suffocates, mutilates, starves, or otherwise causes serious physical injury, a substantial risk of death or a death to a companion animal, or fails to provide food or water to the companion animal, resulting in substantial risk of death or death. There is no escalated penalties or enhanced penalties. Instead, it's just very clarifying definition.
Thank you, madam, for that explanation of the amendment. Do we have any questions for the sponsor of the amendment? Representative Lamar, you recognized.
Thank you, Mr. Chairman. On your amendment, it says includes intentionally or knowingly failing to provide food or water. What if my only question is, what if someone's poor, can't afford dog food? You know, we have a lot of homeless people who have animals kind of walking with them and things like that. Will they get in trouble because they know they have an animal and they know they can't really feed them because they don't have the money? Can you kind of just talk through that for me, please?
Representative Smith, you recognize.
Again, this would be up to the jurisdiction and the opinion of the prosecuting attorney or those pressing charges. I'm sure that all the circumstances around someone's situation would be taken into consideration. I would say this, however, I do know that in most counties, if not all, there is animal control that's available, and animals can be given a surrogate situation to be taken care of in those instances.
Representative Lamar, any follow-up? Okay. Next on the list, I have Representative Griffey.
Thank you very much, Mr. Chair. And my good friend from Shelby County, on that situation, the failure to provide food or water to the companion animal has to result in a substantial risk of death or actual death. So while it's not an ideal situation, it has to be a serious deprivation of food and water that it jeopardizes animals. It's the way I read it. Is that correct, Mr. Sponsor?
Representative Smith.
Thank you, Chairman. And I would agree with my colleague. And again, there's this is not meant to ensnare individuals. Instead, this is a law that allows a prosecutor a very much more subjective means to be able to prosecute rather than the very broad definition of sadistic and depraved manner that many times results in having to bring in a psychologist and or a mental health expert to be involved in the case.
Members, you've heard the explanation. Any further questions for the sponsor? Seeing none, we are ready to vote on attaching amendment coded 6819 to House Bill 733. All those in favor, please signify by saying aye. Aye. Those opposed? You adopt. Members are on the bill as amended. Any further questions? Seeing none. Was there a question? Okay. All those in favor of sending House Bill 733 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? Ma'am, you had to calendar and rules.
Thank you, Chairman and Committee.
Thank you. That brings us to item number 4, House Bill 864 by Representative Chisholm. Motion. Second. Sir, you have a motion and a second.
Thank you, Chair and Committee. I have brought to you House Bill 864, which expands the offense of assault against a first responder and aggravated assault against a first responder to include offenses against nurses. Over the summer, we passed legislation to further protect our first responders. And this bill merely includes our nurses who have been not only the front line of this pandemic, but also the gatekeepers of the health of our state. With that, I have brought, if we could go out of session for a brief testimony, I have Jimmy Closure, who is a nurse at Vanderbilt.
Thank you, Representative Chisholm. Yes, I've got Jimmy on the list. I also have a Kathleen Murphy. Is that correct?
That's correct.
Okay. Without objection, we're going to go out of session. We are out of session, and if Mr. Closure and Miss Murphy are in the room, looks like they are, come on forward. If you could please sit down. The microphone in front of you, if you'll press the button that looks like a mouth talking, the red light will illuminate. Whichever one of you will speak first, just identify yourself for the record, first name and last name, and then you have 4 minutes to share with the committee whatever you'd like. At the end of that time, there'll be unlimited time for question and answers, but you'll have 4 minutes uninterrupted. So you're recognized.
Thank you. My name's Jimmy Klosser. I'm a advanced EMT registered in the state of Tennessee. I'm also a registered nurse, a certified emergency nurse. I work at Vanderbilt University Medical Center in the ER. I also coordinate the stroke program there. You want me to keep going? Okay. I guess the reason I was called here today is to kind of tell my story. I've about 13 years in the fire, EMS, and nursing community. I love what I do. I love taking care of my patients. I love helping get patients well. What happens in the ER and other units is sometimes incredibly demanding. We are attacked. There's many cases of nurses being attacked egregiously. That goes unprosecuted. It goes unreported many times because they feel like nothing will happen. Other times, it's just they feel like it's not worth their time. So my story in 2015, I was taking care of 3 patients in the emergency department. I had 2 critical patients, one that was less critical. I was helping the patient by the patient's request to get up to use the restroom. So when I entered the room, I was detaching some of the IV tubing. And all of a sudden, out of nowhere, I was punched multiple times in the face. I was then grabbed by my lanyard, which unfortunately wasn't a detachable lanyard. And I had my stethoscope around my neck. And so both of those things pulled me down. We went down to the bed as the patient did so and increased the tightness around my neck. The patient kept saying, "I wanted to kill you. I hope you effing die." There was a lot of other expletives in there that I'll just withhold from in the testimony. But luckily there was a security officer walking by and tried to help separate us. The problem was the security officer landed sort of in the elbow area of the patient. And so that even increased the amount of leverage on me. If it wasn't for my stethoscope breaking in half, I would have probably died. I was about to gray out. I was blacked out. I woke up in the middle of the hallway, somehow without a shirt on. And I had a bunch of lacerations to my neck. I had to be checked into the emergency department where I worked and give up taking care of my 3 patients who were incredibly sick. I remember waking up and trying to go check on one of my other patients because they had a heart problem and we were trying to slow their heart rate down. But anyway, it was incredibly traumatic. It was incredibly emotional. I'm a tall guy. We have nurses that are very tiny. I'm doing this today to stick up for all of my friends and colleagues throughout the Tennessee area that are nurses, to have something will happen if charges are pressed. If this escalates to a felony level charge for assaulting a healthcare provider, people might think twice about doing so. And then that just goes into the rest of the story of the prosecution. Ultimately, I pressed charges. And after a couple years, there was really nothing that materialized as far as accountability for that particular patient. Each case is different. I realize that. But I'm really hopeful today that you guys are supportive of increasing the penalty. Because here's the other thing, guys, is when this happens to us, it makes us want to get out of the career that is, we have a huge nursing shortage in the state of Tennessee. And every time this happens, I mean, I wanted to quit. I took a 6-month sabbatical in 2017 because of this. And I haven't been the same since, you know. I battled some depression. I battled, emotional, whatever you want to call it. I feel the best I've ever felt now, but that's, 4 years later. So, or 5 years later now. That's
Thank you.
basically what I have.
Thank you, sir. Thank you for sharing that with us. And next on the list, I have Kathleen Murphy. Ma'am, if you could just introduce yourself for the record, and again, you'll have 4 minutes for your testimony.
Sure. I'm Kathleen Murphy with the Tennessee Nurses Association, and I'm only here to answer questions if y'all have any.
Okay, great. First on my list, I have Representative Beck. You're recognized.
Thank you, and thank you, Nurse Klaus, for being here, and I'm so sorry for what you've been through. Have you witnessed this, or have you heard about this happening to other nurses?
Oh, man.
Closer, you're recognized.
Yes, sir. I just talked to a nurse walking out of the hospital today that had been punched, and she knew of my case. And with Vanderbilt Police Department, they did not press charges because they didn't think anything was going to happen from it. She's very tiny. She's probably like 4'11". I just feel for everyone that's not as big as I am. It happens all the time. I have probably 10 or 11 people that have come up to me just at Vanderbilt alone that have kind of said, hey, like this happened to me too, whether it be punched or slapped or spit on. There's objects thrown at healthcare providers. It's widespread. I know if it's happening in my department where we have just over 300 emergency nurses, it's got to be rampant throughout the state. And I've heard friends in Chattanooga area as well talk about this as well.
Thank you, sir. Representative Beck for follow-up.
So the injury and the emotional distress that you spoke about, did it ever make you think about leaving your profession?
Yeah.
Mr. Closer, you're recognized.
Thank you, sir. Yeah, I took that sabbatical, as I mentioned. I love what I do. And if it wasn't for kind of taking over some of the roles in the stroke department, I probably would be out of the profession at this moment. If it wasn't for my incredible boss now and the support that I had from my institution, I would not be in the healthcare industry. I'd probably be selling something or whatever.
Representative Beck, you're recognized.
Thank you, Mr. Chair. Thank you for that testimony. Thank you for continuing to do what you're doing.
Thank you.
It's so vital, and we've seen that through this pandemic and so many things that you face, and we thank you for that.
Thank you.
Thank you, sir. Next on my list, I have Representative Griffey. You're recognized.
Thank you very much, Mr. Chairman, and thank you, Mr. Closter and Ms. Murphy, both for being here. I kind of wish that before this committee voted on a number of our legislations that we actually had a chance to hear from victims and the real world stories that happens. I've got a number of my family members are in the medical profession, and that you hear stories like this anecdotally. I suspect that what happened to you is not an uncommon occurrence throughout the medical industry. And if we don't set a bright line and say, we're simply not going to tolerate this kind of actions against our healthcare workers and protect them, we're going to fall on our mission. So we need to do that. And I appreciate you coming and giving us your testimony. Thank you, Mr. Chairman.
Thank you, sir. Next on my list, I have Representative Hardaway. You're recognized.
Thank you, Chairman, and thank you for being here today. My favorite folks, as most of my colleagues know, are nurses and teachers. Okay? Both of you choose a career as opposed to a job. And it's that dedication with that passion that causes us to have one of the best healthcare systems in the world. Whatever we can do to protect you so you can continue to protect us, we need to do. If this bill will serve as a deterrent by increasing the penalties and make that buzz happen to where folks are talking about it so that you don't have to endure the abuse, you and your colleagues don't have to endure the abuse, I would suggest that it's not only about the physical abuse, but it's about the emotional, the psychological trauma. Any of those items would keep you from doing the very best job you can do. So I would ask that my colleagues would give this bill a favorable vote so we can show our support for you and we can put a deterrent in place that will allow our first responders, no one's more important than our healthcare workers, and there's no healthcare worker more important than the nurses. Let's make this bill happen so that we can protect our nurses. Thank you, Mr. Chairman, and thank you again for being here.
Thank you, Representative Hardaway. Next on my list, I have Chairman Moody.
Thank you very much. Thank you both for being here, and thank you for what you do in each of your roles. So I'm just sitting here thinking, men are usually the worst patients. Do you have any thoughts about your experiences? Does it play out, men, women, ages? I'm just curious. I know you don't have a
It's funny you say
countrywide
that.
sampling.
It's funny you say
Mr.
that.
Closer, that may be a setup. I don't know if you want to answer that or not. You're recognized.
Honestly, I didn't mention the gender of the patient who attacked me, but it was actually a female patient that attacked me, a very strong CrossFit female that attacked me. And I do see it probably equal from both genders, if that was the question.
And not to make light of the situation, but I was curious about
Yeah,
how we know our men handle sickness sometimes. But anyway, thank you again.
Sometimes grumpy.
Thank you. Thank you.
Thank you, Chairman Moody. Next on my list, I have Chairman Doggett. You're recognized, sir.
Thank you, Mr. Chairman, and thank you both for being here today. My wife was a ER nurse at a level 1 trauma unit in North Alabama. She worked night shift, so I've heard all the stories that you can imagine. I know you've seen them, so it's very active. Could you, and I know that the main focus of our conversation today has been around the ER, but as a nurse and your medical experience, there are other places that we may not see here in this committee that a nurse would maybe come into contact with somebody that's being combative or being assaultive on them. Could you share some other places that nurses, that this would help nurses in other areas of the medical field as well?
Mr. Closer, you're recognized.
Thank you, sir. Just my office currently is on a medical surgical floor. And so those instances also happen not only in the emergency department or in pre-hospital setting in the ambulance, but all across any healthcare institution. It happens quite often. We're very fortunate to have a great police department in our hospital that is trained in de-escalation and is trained in a healthcare setting for specific tactics that are de-escalating. But many hospitals don't have that luxury, and they actually have to call like the local sheriff's department or police department for them to respond in. They're not in-house, so that response time is extremely lengthy at times. So that's an internal process per hospital, but you're absolutely right. It happens all across the hospital, nursing homes, you name it. It's even with family members. It's not just the patients.
And Chairman, if I may add, the statistics are that 1 in 4 nurses are assaulted on the job, and about 13% of sick leave or time off is caused because of workplace injuries or workplace violence. And so those statistics, I think, very clearly demonstrate that this isn't just in the emergency room to kind of reach those statistics. And so it is happening not just from patients, like in this situation, but from family members of patients as well, because any floor that you're on or any setting that you're in, it's going to be a high stress and emotional situation anytime you're dealing with a family member's healthcare or your own.
Chairman Doggett, any follow-up?
No follow-up. Thank you very much.
Thank you. Members, I have no one else on my list, so without objection, we will go. Thank you very much, both of you, for being here. Thank you for sharing your story with us, sir, and we'll go back into session.
Thank you, everyone.
Thank you. That brings us back to Representative Chisholm on House Bill 864. Any questions, Representative or Chairman Halsey? You're recognized.
I thank you, Mr. Chairman. I hate being the lone opposer. I don't mind at all enhanced bills and enhanced punishment for events. I have a problem with the law in this regard, and that is if you have a nurse in an emergency room, and there's a custodian in there with her cleaning the floor, and she's treating a drunk guy, and he gets mad and punches her in the jaw, and then he punches the custodian in the jaw. If we pass this bill, you charge the punch against the custodian as simple assault, misdemeanor. The punch against the nurse is a felony. Now you have the blindfold off the lady. And I believe for a long time that law gets its righteousness from its equity, which means that the nurse's jaw is worth the same amount as the custodian's jaw. So I have some problems fundamentally with this bill. I'd much rather if you made a law that says anytime you get assaulted on a hospital property, that's a felony, as to begin to separate classes of people by law. That's my opinion.
Chairman Halsey, I do want to point out, it looks like at the bottom of page 1 on this, I believe, just to jump in, I believe the punch against the nurse in your example would be a Class A misdemeanor, just to clarify.
Even after, excuse me, thank you, Chairman, even after this bill is passed.
That is my understanding, but we can go out of session here from legal if you'd like.
Okay, and as a disclaimer, I have a daughter who's a nurse and a son-in-law who's a doctor, so.
I understand. I just wanted to make sure that we had that, but it says Section 1C1, assault under subsection A is a Class A misdemeanor and shall be punished by a mandatory fine of $5,000 and a mandatory minimum sentence of 30 days incarceration. So I think it is a greater penalty, but it just wouldn't be a felony. I've got several on the list. Okay. But Chairman Halsey, did you have further questions? Okay. All right. Next on my list is Chairman Doggett.
Thank you. I was thinking about some other comments that were made. Very appreciative of that. I do have it just came to me earlier, and I just was curious about this. You have school nurses that work in the school systems. If they're assaulted by a student, are there any provisions that deal with that in this bill, or is it something totally different, maybe that would go through juvenile? But that just, if we're making an enhancement here, would it carry over into the juvenile realm if there was maybe a student assaulted a nurse while she was in the process of her duties or his duties? Thank you.
Representative Chisholm, you recognize.
From my understanding, this particular piece of legislation doesn't open up the juvenile section.
Chairman Doggett?
Okay, thank you. And I have one other question, Mr. Chairman.
Yes,
if
sir,
that's
you
okay.
recognize.
And also, I noticed in there, CNAs, Certified Nurse Assistants, I did not see that listed in here. It said Title 67, Section 11, something along those lines was or Section 7, maybe it was, or no, it was 11. I guess. I don't know. Anyway, what I'm saying, it comes down to medication aids in there. Would that be something, maybe we have to ask legal if that would apply to CNAs as well, Certified Nurse Assistants?
Okay. Without objection, we're going to go out of session here from legal.
Michelle Fogarty, Legal Services. The bill defines a nurse as a person who's licensed, registered, or certificated under Title 63, Chapter 7. So if they are covered by that, then yes, but if they're not, then they would not be included in this bill.
Chairman Doggett, do you have further questions for legal? Okay. Any other questions for legal while we're out of session? Seeing none, we're back in session. Chairman Doggett, any further questions for the sponsor? Okay. Next up, I have Representative Hardaway. Although if you have somewhere to be. Okay, no problem. Leader Lamberth, you're next. Pass. Okay. That brings us back to Representative Hardaway. He's back. Representative Hardaway, you recognized.
Thank you, Mr. Chairman. I was checking to make sure that we did cover CNAs, and they are. So what I want to emphasize is if we're talking about first responders carrying out their official duties, that's a little different. And thankfully, we share that extra concern when we talk about judges, we talk about police officers. If someone's helping them in a situation, striking a police officer is a little different. Striking a judge in the courtroom is a little different than hitting the clerk or one of the witnesses. So I'm for the bill. I thank you, sir, and I urge my colleagues to support it. Thank you.
Questions have been called. All those in favor of sending House Bill 864 to calendar and rules, please signify by saying aye. Those opposed, sir, you had to calendar and rules.
Thank you, Chair. Thank you, committee.
Thank you, sir. Members, item number 5, House Bill 1434 is off notice. That brings us to item number 6, House Bill 1406, and I will pass the gavel to our Vice Chairman.
Thank you, Mr. Chairman. You are recognized on House Bill 0880.
Thank
No,
you, sir.
Excuse me, that's the wrong one.
It's okay.
House Bill 1406.
Thank you, sir. And I do have an amendment I wish to move today, coded 4896. Second?
We have a motion and a second on the amendment. All in favor? You want to talk on the amendment first? Question's been called on the amendment. All in favor, say aye.
Aye.
Opposers, no. The amendment has been put on to the bill. You're recognized on the amendment.
Thank you, Mr. Chairman. Thank you, committee. Members, this bill as amended comes from a lot of work that was done over the summer to analyze and improve law enforcement's use of force policies. Most of what you see in this bill is already in local law enforcement agencies' use of force policies, but the governor commissioned a group to get together, which involved the chiefs of police, the Tennessee Sheriff's Association, the Tennessee Bureau of Investigation, the Tennessee Department of Safety and Homeland Security, the Tennessee Highway Patrol, the Tennessee Department of Commerce and Insurance, and the Tennessee Peace Officer Standards and Training Commission to enhance policies, improve information sharing, and increase officer training. This partnership resulted in the governor's Use of Force Policy Committee, which issued recommendations on September the 10th, 2020, in the form of sample use of force policy for law enforcement agencies to adopt across this state. This bill, as amended, seeks to codify these best practices to ensure that the men and women of law enforcement continue to excel in their role of keeping Tennesseans safe. And quite frankly, I think it goes a long way to showing the rest of the country that in Tennessee we lead, we do things correctly, we do things above board, and I ask for your support and seek passage of this legislation.
Okay, we have the amendment. You've heard the explanation. We have
We're on the bill.
Leader Lambert, you are recognized.
Thank you, Mr. Vice Chairman, and to our chairman, thank you for all of your hard work on this, and we actually really appreciate your work throughout this entire year. You've led our committee very well, so thank you. I know you did a deep dive in this. I was uncomfortable with the last section and language in subcommittee. I still believe that no-knock warrants should have guardrails on them. I think we should put that bar extraordinarily high. There are rare circumstances where there are direct threats to law enforcement, where individuals articulate before a search warrant or any action is taken by law enforcement that they intend to kill members of law enforcement or anyone else that comes in. That's the circumstance that a no-knock warrant should be utilized. We've seen stories in the news and in the media where literally lives would have been saved had a no-knock warrant been used. I understand that this is a very passionate issue for folks. I'm not going to let that one aspect of a bill get in the way of my vote in favor of the rest of the parts of this bill. So I've had raised concerns in subcommittee. I think this will be an issue that we wind up revisiting in a few years. I hope that it is not an issue that puts someone in a situation where it costs their lives. And I'm asking all of our law enforcement officers to pay very close attention to this bill, follow the tenets of it, and literally do what you do best every day, which is go out there and save lives, but keep our officers safe too, because this is a bit of a shift. I mean, these no-knock warrants are extremely rare to be used. And it will change the way law enforcement approaches this. I actually hope that long-term it will mean that folks are safer. I really do. And Mr. Chairman, I know that's what your goal is. So I had raised questions and concerns in the subcommittee, and so merely wanted to state on the record that I appreciated your work and will stand in favor of this bill today. That's just one vote. I can only speak for me, but it's just a lot of work that's been done between you and everyone else. So thank you for that hard work.
Thank you, Leader Lambert.
Representative Dixie.
Thank you. I would like to echo what the leader just said behind me. I know it took a lot of work to go in here, and I know it took a lot of movement to get, especially Leader Lambert, to where he is now. I've talked to him too, so I know he's hard to move on certain things. But I think this is a great bill, and I appreciate everything that you've done for it. Because last year, several of my Democratic members, we had amendments that pretty much addresses everything that touches on here today. So I'm glad that you were able to roll that into this bill, because this is a much needed, and it will save lives, many lives, whether it's law enforcement or just the regular citizens on the street. So thank you again for putting in the time and seeing the need for this. Thank you.
Representative Hardaway.
Thank you, Mr. Chairman. And I certainly appreciate the sponsor bringing the bill. The contents of the bill, they're not perfect, but they're certainly light years away from where we are now. And they will get us eventually, because there's a data collection and data analysis, the ability to measure how this works out. That's even, if not more critical, as critical as the actual steps that we're taking today. Because that data collection, that analysis of data will allow us to fine-tune and tweak what we're doing today. And everything from the use of chokeholds, de-escalation, which I think we need to start adding the category of non-escalation into it, but retaliation against officers who intervene or report excessive use of force or other violations. All that's important when it comes down to transparency. The relationship between the public and law enforcement is critical to the ability of law enforcement to carry out their job. Without that trust factor, law enforcement can't maximize their mission to protect the community. So I think this goes a long way towards making that happen, and I applaud the sponsor and those who have worked on this bill and the governor's office, and I urge my colleagues to support it.
I don't think we have any other questions, so if there's no objection to the question, we are voting on House Bill 1406 as amended. All in favor say aye. Aye. Opposers, no. Motion carries. Bill goes on to calendar and rules.
Thank you, Chairman. Thank you, committee. Members, that brings us to our addendum calendar today. And on that addendum, we have one item. It's House Bill 880 by Chairman Terry. Chairman Terry is with us today. Sir, you are recognized. Sir, you have a motion and a second.
Thank you, Chairman and Committee. House Bill 880 decriminalizes patients by removing the simple possession charge for patients who comply with the provisions of the bill. Qualified patients or caregivers may possess up to the equivalent of half an ounce of marijuana or 2,800 milligrams of THC in non-smokable, non-vapable, non-edible cannabis-based medicines. And I believe the committee does have a friendly amendment.
Thank you, Chairman Terry, for that explanation. And yes, I have actually filed an amendment. It is untimely, so the committee would need to vote whether or not to consider that amendment. I'm happy to explain what the differences are. It's in the final section of the bill dealing with a patient's right to carry and use a firearm. And I've spoken with Chairman Terry about this, and Chairman Terry, I believe your intent is to make sure that just because someone has a prescription or one of these authorizations from a doctor does not mean that they forfeit their Second Amendment rights. And so this amendment just tightens that up a little bit. Inadvertently, we were saying that folks could carry a weapon if they were under the influence, and that's not how we treat any other drugs. And I don't think that was the intent of your language. And so I think this amendment, if you all will consider to hear it, more closely reaches the chairman's intent with regard just to that carry piece, the Second Amendment piece. Thank you. We have a motion and a second to consider the amendment. All those in favor of considering the amendment say aye. Those opposed? Okay, we will now consider the amendment. Members, again, you've heard really the rest of the amendment is identical to the chairman's language, but this is amendment coded 7768, and it would just tighten up that language about not being able to carry if you were under the influence. Question's been called on the amendment. Oh, sorry, a motion on the amendment. Do I hear a second? Okay. All those in favor of adopting amendment coded 7768 to House Bill 880, please signify by saying aye. Aye. Those opposed? You adopt. The amendment is on the bill. Chairman Terry, we're back to you. Again, everything else is the same in it was in your original bill.
Thank you. And thank you, Chairman and Committee. And again, I appreciate you. That's why these bills go through several committees, because folks on other committees can dive down a little bit deeper, and appreciate you enhancing the intent or finding the intent of what I was looking at. At its heart, this bill is a criminal justice reform bill for patients and an opportunity to advance science by allowing Tennesseans to participate in cannabis medical research. It sets up a bookend study program and directs the Department of Health to conduct a baseline study of medical cannabis licensure in contiguous states due by December 15th, 2021, and a follow-up study, including any positive and negative effects of medical cannabis, utilizing Section 2 of the bill on patients and physicians in Tennessee by December of 2024. It establishes that a bona fide patient-practitioner relationship must exist between the patient and the physician. A qualified patient or the caregiver must possess a letter of attestation from their physician that includes their qualified disease or diagnosis, that the patient has received conventional methods of treatment for the patient's qualifying medical disease or condition, and those methods have insufficiently addressed the patient's disease, condition, or symptoms, or that the patient is enrolled in a medical or clinical trial and is dated and signed by the physician. There are a list of 11 qualifying diseases. Again, as I said, it's non-smokable, non-vapable, non-edible. There is a list of acceptable forms that the cannabis can be in, and it's limited to 2,800 milligrams of THC. The cannabis medicine must be in the original container with dosage information. Again, the bill does not allow for smoking or vaping of cannabis. The patients are still subject to the drug-free workplace program. All HIPAA rules do apply. As we said in the amendment, firearms rights are protected, and this is under the sole, if it's the sole reason for that, and the DUI laws will still be enforced. What the bill does not do, it does not allow for Tennesseans to grow. It does not allow Tennesseans to smoke, vape, or eat cannabis, and it doesn't set up any system for licensure or dispensary or facilities. And I believe, I'm happy to take questions, but I believe there are people here that would like to testify.
Yes, sir. We do have quite a lengthy list of folks who would like to testify. So if there's no objection from the committee, we will go out of session to hear that. So we're out of session. We have several on the list today. So to try to at least be as efficient with our time as possible, we're going to go with kind of a panel model, which we've done in this committee in the past. So first up, there is a panel of folks to testify from the administration. So if they are here, I've got Elizabeth Stroker from the Department of Safety. I've got Patrick Powell from the Department of Health, and I've got Callan Schmid from the Office of the Governor. If you could please make your way to the front. You are all very familiar to this committee, but if you could please make sure your microphone's on, introduce yourself for the record. You will have 4 minutes apiece if you'd like to take that long, and then there will be an unlimited time for question and answer at the end of the third testimony. So who's up first? Ms. Schmid?
I'm Callan Schmid, Legislative Liaison for Governor Lee's office. First, I want to say thank you to the sponsor for the many conversations that we've had with him about this topic, and we appreciate it. Unfortunately, the governor is opposed to this legislation. He has been consistent in his position that until the federal government reschedules this drug, he is opposed to doing anything at the state level. And I will defer to the departments to the specific legislation and the implementation issues.
Thank you, ma'am. Who's next?
I'll go briefly because I think most of the concerns, obviously, for this committee would be left to safety, but Patrick Powell with the Department of Health. The department, of course, as part of the administration, is opposed to the legislation. The list of conditions still gives the department concern. We would like to see the normal FDA processes for safety and efficacy be tried. We're treating this drug differently than every other drug in history by doing this kind of piecemeal approach. A number of the conditions listed, there's very limited evidence that it's beneficial. Most of them, it doesn't actually treat the illness itself. Some of them, it has limited evidence that it may help symptoms, things of that sort. And there are already synthetic approved FDA products such as Marinol, Epidiolex, so forth, that are have gone through the processes for safety and efficacy. So ultimately, we do not see the need for this at this time and would like to see the drug rescheduled on the federal level. And again, those normal safety and efficacy processes followed.
Thank you, sir. And that brings us to you, Ms. Trugger. You're recognized.
Hello, committee. All of you know who I am. I visit this committee quite often. Elizabeth Stroker, Legislative Director, Assistant General Counsel for the Department of Safety. And to echo my colleagues' concerns, Chairman Terry and I have gone back and forth for a few years now on this topic. And I respect the chairman very much and his intent with this bill. And, as we've said, kind of similar to what Callan's saying, as soon as it is rescheduled and treated like a drug, law enforcement will be the first ones to come to the table and make sure that's done safely and, under the supervision of doctors. But I wanted to focus on not the intent, because I know the intent is very good. I wanted to focus on the actual problems and inconsistencies with the language of the bill itself and that impact that it's going to have on law enforcement trying to enforce it. The first thing is, while there is the first section of the original bill dealing with the firearm rights removed, which dealt with law enforcement's ability to restrict carrying or possession, the other two sections still create a problem. One of them says we couldn't use state resources or personnel to enforce federal firearm regulations, and there is a federal and state disqualifier if somebody is a known addicted user to any controlled substance, regardless of what it is. And obviously that would be something that the state has to enforce both on the state and federal level. And so that portion is still very troubling because we wouldn't be able to take action if somebody, is addicted, which may be okay based on their condition, not getting into that aspect of it because I'm not health. But if, they are impaired, which we know that this drug does impair your cognitive functions, we wouldn't be able to follow those state and federal regulations in regards to someone who may be addicted to a controlled substance. The other piece of the firearm portion is that we cannot charge them with the offense of carrying with the intent to go armed solely based on their status as a user under this bill, which, again, not going towards that portion of it, but it's kind of like Patrick said, every other drug, legal, prescription or not, somebody is still held to be responsible for those, for their actions. And the piece was included in here for DUIs because we have, I think the past 5 years, we've seen about 1,200 accidents where marijuana was a contributing factor, and 100 of those were fatalities. And so we know it does impair people. And so we would ask that people driving or carrying weapons be considered like anyone else using any other drug, legal or not, and that law enforcement be able to make sure people are safe. A few other things, while the bill says that it cannot be used in a form to be smoked or vaped, one of the products allowed is oil. And so that's where it's inconsistent because it says you cannot have it in any form meant to be smoked or vaped, but oil is the only form that you can vape it, and that is allowed. And so what does law enforcement do whenever those two sections completely conflict with each other? Another big problem is hiring and our own employees. Since you have, PTSD or some other diseases that people may have and qualify under this bill and legally be using under this bill or having under this bill, there's also a provision that says everything is HIPAA protected. And while it says you can't impact hiring or firing or drug-free workplace, everything's HIPAA protected. So let's say you have an officer who has PTSD and, he's commissioned, he's a patrol officer. Would we even be able to ask him, while he may legally have it, he may need to be, while he's using it, he or she be put on desk duty or not driving or not be a commissioned officer. And we would like to at least be able to ask to make sure they're safe and everyone else interacting with them is safe. And so that's another kind of inconsistency with the bill, with the two sections just not going together. And one other final thing, because I know I'm probably getting short for time here. You're talking.
Ma'am, I'm sorry, we are at 4 minutes.
Okay.
So, yeah. Thank you. Any questions for the administration panel? Representative Lamar, I have you on the list first.
Thank you, Mr. Chairman. Thank you all for your testimony. You stated that there has been 1,200 accidents where marijuana was a contributing factor. Could you clarify was it marijuana alone, or were there other substances involved in those accidents?
Ma'am, you're recognized.
I don't have that exact clarification, but I can say that it was a contributing factor in at least 1,200. And I want to clarify that because once, and talked with TBI on this, testing for marijuana isn't always done on every single situation. If the blood is tested and they hit that DUI threshold of 0.08 for alcohol, then they're not going to test for those drugs. So it's at least 1,200 that we can show.
Representative Lamar.
Thank you, Mr. Chairman. But we don't know if it was marijuana alone. We're saying it contributed, but we're not stating that marijuana alone is the cause of accidents. So I just want to make sure that's clear that we're not saying you're not saying these accidents were just marijuana by itself.
Ms. Drucker.
I'm not saying that. I'm saying that it is either contributing or it can be by itself. It can be either.
But we don't know if it's.
Representative Lamar.
Oh, sorry.
I apologize, Mr. Chairman.
That's okay.
Recognized.
You're recognized.
Thank you. So but you're not saying that it's the sole factor, and that is what I'm trying to clarify.
Ms. Drucker.
I can say that. I just don't have those numbers in front of me. I would just have to go and pull it. But we can test for that and show that.
Representative Lamar for
That all 1,200 were marijuana was the sole factor.
Ms. Drucker, if you have an answer to the question.
No, again, I've said that 1,200 at least have marijuana contributing, whether it's contributing or the sole factor.
That's all I have.
Thank you, ma'am. Next on my list, I have Representative Griffey. You're recognized.
Thank you very much, Mr. Chairman. Is there anybody else going to be speaking for the bill, in favor of the bill?
We have several panels of
Okay,
testimony.
then I'll wait.
You
I'll
wanna
hold
wait
my
till the-
questions.
Okay,
Thank you.
all right. We'll keep you on the list for later. Members, any other question for the administration panel? Vice Chairman Sexton, you're recognized.
Thank you. This is for Callan. You had said that the governor's office would not be for this until it was passed on the federal side. Is that correct?
Ms. Schmidt,
Yes, sir, that's correct.
Vice Chairman.
My question is, and maybe this is for legal, but if we pass this, then would it be illegal on the federal side, or would it be legal from the state side? How's that work?
Ms. Schmidt, do you wish to address that, or should we go to our legal?
I'm not. I'll defer to legal.
Okay. Would you like to ask that question of legal services?
Yes, please.
We're already out of session, so we will go to legal services.
Michelle Fogarty, Legal Service. It would still be a federal offense. You'd still be violating federal law.
Vice Chairman.
So we would be passing law that was violating federal law.
Possession of marijuana is a violation of federal law. Yes.
So then would it be violating federal law? Correct? I mean, there's no other way to say it, right?
Yes, possession of marijuana is a violation of federal law. And so people, if you pass this bill and people were possessing under the authority of this bill, they would be in violation of federal law.
Vice Chairman. Thank you, sir.
Oh,
Vice Chairman, you're recognized for follow-up.
With that said, we know that there's other states that have passed like legislation, and so they're not being prosecuted on the federal side. So I think that Tennessee, and we do have states' rights, I believe that we'd be well within our rights to say that we have states' rights, because evidently the federal law is ignoring it. And while I don't agree with ignoring some and not on the others, I believe that Tennessee ought to do as we please or as we see best for our state. I don't want to wait on the federal government actually for anything. So, but thank you anyway.
Thank you, Mr. Vice Chairman. Next up, I have Representative Hardaway. You recognized?
Thank you, Mr. Chairman. And, you know, I might need a little something because I am now in complete agreement with the Vice Chairman on states' rights
Welcome to the 10th Amendment Club, sir.
in this instance. So, just a couple of things I want to try to clarify from the Department of Safety on the 1,200 contributing ore and the 100 soul factor instances of data that you suggested pertains to marijuana use. Is there data that will tell you whether that marijuana, two things, whether it was smoked or somehow ingested through a different means, and how many of those folks were under the care of a doctor?
Ms. Stroker, you're recognized.
Yeah, and I want to clarify because the 100 number is 100 fatalities. That is not 100 where marijuana was solely contributing. The solely contributing, I would just have to go back and pull that information. I just don't have it offhand. I just have where it's at least a contributing factor. And I'm trying to remember your question. Oh, on if they were under the care of a doctor or if it was smoked or vaped. No, you cannot tell how the substance was taken. That may be a better question for TBI when they come up, but I don't believe that you can tell that. And as far as if they're under the care of a doctor, maybe if you go and talk to the court, they might know, but law enforcement is not going to know on the side of the road unless that person volunteers that information when they're stopped or arrested or whatnot.
Representative Hardaway, you're recognized.
All right, thank you. And I would agree that on the side of the road, they may or may not know. But if we're going to cite statistics, then we should have it broken down. If these individuals have been prosecuted, then that information surely should be available. So I'm going to suggest that, some may have been prosecuted, some may have been the victims of individuals who were under the influence of something or the other. So I would suggest that the investigation should yield the information that I just asked for. The other thing that, were you looking to respond? Okay. On the issue of firearms and the ability for those individuals who are under the care of a doctor to have those Second Amendment rights available to them. I don't quite understand the argument against that unless we're arguing that any medicine that could lead to an addiction or could lead to a situation where you're not in control of your faculties, that if you have a prescription for any of those, that you lose your Second Amendment rights. I don't see how you single out marijuana, medical marijuana, for that. response, Mr. Chairman.
Ms. Stroker, you're recognized.
I was just didn't want to go out of order here. A few things that you mentioned. The person, while they're under the care of a doctor, they're under the care of a doctor for a listed condition in the bill. They're not being advised on marijuana or if it would help them or hurt them, and it's not being prescribed to them by this doctor. They're under the care of a doctor for one of the listed diseases or conditions in the bill. So that's a little bit of a difference, is they may not know what the problems are because the doctor is not advising them on that. And to your second point, actually, it actually is federal law and state law that you cannot be a known addict or user of a controlled substance to purchase, possess, transfer firearms. So yes, like every other drug, if you have a problem with it and it's clearly a problem for you, no matter what drug it is, and we're asking that if it be treated as medicine, as the bill is laying out, as medical marijuana, that it be treated like every other medicine, that if you are abusing it and it's impairing you, that you not be allowed to drive, which was included in the bill, and that law enforcement be able to potentially remove a dangerous weapon, not based on that status alone, but if you are an addict or user of a controlled substance to a detriment. That is current law.
And Ms. Stroger, to be clear, I think the amendment that we adopted addresses that aspect of it, does it not?
Mm-mm. No, it only deletes the section of it that said state agencies or law enforcement could not infringe on somebody's right to purchase, possess, transfer. It still has the section that says you cannot charge them with the offense of carrying with the intent to go armed, and it still has the section that you cannot use any state funds to use or enforce any federal requirements. And I could be misreading that, but that's how it was explained to me, is that it still would be inconsistent with those federal requirements.
Thank you, ma'am. Next up, I have Representative Hawk. You recognized? Yes, Representative Hardaway. Oh, follow-up. Okay. You're recognized for follow-up.
Thank you.
Okay.
Two things that concerned me in your response was that there was no doctor advising, and I'm trying to figure out if this is a medical marijuana bill, why you would say that there's no medical advice involved.
I'm going to defer to health on that.
And Representative Hardaway, the way the bill is written, it is the physician in state would diagnose with the condition, but does not prescribe the marijuana. The marijuana would be obtained out of state. So there is no kind of requirement that the person would continue treatment with any kind of physician out of state. There is no kind of requirement about any kind of dosing or anything with the physician in state. It is merely, for lack of a better description, a blank check where the physician has diagnosed you with a qualifying condition, and then you are free to go outside of the state and then free to possess the marijuana you've brought back in state.
Representative Hardaway.
Thank you. And without the diagnosis, then you don't have a right to get the drug and bring it back.
Under the bill, that the qualifying diagnosis would allow you to possess.
Representative Hardaway.
All right. Thank you. I think that was a qualified yes. Well, I have some other things, Mr. Chairman, but for the sake of time, I'll yield the floor.
Thank you, sir. And I don't want to harp on this too much. It's kind of the tail wagging the dog, but the way I drafted the amendment was that you could not use federal funds to remove the weapon if someone was authorized to use, but you would be able to remove if they were using. That was the way we drafted it. That's the way the committee adopted it. So just want to be clear about that.
And I'll obviously defer to you there. So I could definitely be wrong. I've been wrong before.
Thank you, ma'am. Next up, I have Vice Chairman Russell. You recognized?
Thank you, Mr. Chairman. My question is for the governor's office. Has he indicated that he would veto this bill if we pass it?
Ms. Schmidt, you recognized?
Currently, the position is that the governor is flagged on the legislation. It's a consideration that he would have to make if it makes it out of this committee and makes it through the process.
Vice Chairman Russell.
So he's not indicated either way at this time.
Ms. Schmidt.
to my knowledge, it's a conversation that he would have to have looking at the final amendment that passes on the floor and, makes it out of this committee and that sort of thing.
Vice Chairman Russell.
Thank you.
Okay, I have no one else on the list for the administration. Okay, Representative Lamar for the administration panel.
Thank you, Mr. Chairman. I appreciate it. I'm sure health can probably answer this. How many people, not including accidents, but how many people have actually died from using marijuana in this state?
I don't have that number.
Does anybody know how many people have died from using marijuana alone? How many people?
Representative Lamar.
Do you know how many people have died from alcohol use or opioid use?
Sir, you recognize?
Thank you. I don't. I could look up the totals for you, Representative, but I don't have those with me. I apologize.
Representative Lamar.
Last question. Have you actually heard of a case where someone has died from using marijuana alone that's not involved in an accident?
Mr. Powell, you recognized.
I'm aware of THC overdoses, but I do not know if they have been fatal or not.
Okay.
I simply don't know. I'm sorry, Representative.
Next on my list, I have Chairman Doggett.
Thank you, Mr. Chairman. My question is for safety. You had mentioned earlier in your testimony about and use the example of a trooper that may have had experienced post-traumatic stress syndrome in the past or had that big diagnosed with that at one time, and that under this, their doctors know that would be HIPAA protected so that you as the employer, the agency would not know that information. Can you expand on that a little bit for me, please?
Ms. Stroker.
Yes, and it's one of those where another piece of the bill where it's not clear and the language is inconsistent between sections of the bill, because when you start reading it, it does say that it wouldn't impact drug-free workplace or an employer's right to hire or fire, but then you continue to read on and see that everything is HIPAA protected. And so we're put in that situation where the section on drug-free workplace and hiring and firing is great, but then what happens now that we have the section on everything is HIPAA protected? I don't know if we could even ask that employee or if they would have to tell us if we did ask, which is something we would like to know. And so it's one of those things where the bill just is a little inconsistent or it's unclear on what the outcome would be in that situation.
Chairman Doggett.
Thank you for that. Mr. Chairman, do you know if we'll have anybody from workforce and labor be testifying on this today, or?
We, after this, we have a law enforcement panel, and then we have a panel that is here to testify in favor of, but I don't see anybody on there from the Office of Workforce Development.
Okay. My follow-up question to that would probably be more suited for them, but as an employer, and you have an employee who is prescribed certain medications, some things you do not want them operating heavy machinery, such as a pickup truck or a car, a vehicle, not just cranes and tractors and bulldozers and those types of things. Heavy machinery is considered vehicles as well. And so I would just be curious as to if that would be something that they would have to disclose, that for this condition, they take a pill or they use a cream or wear a patch at night or something like that. So, but thank you for your answer.
Thank you, Chairman Doggett. Next on my list, I have Vice Chairman Sexton. You're recognized.
It is my understanding that if you take a drug test and you have doctor prescribed medication, that otherwise it would be illegal for you to work, but the levels of opioids or hydrocodone, other types, you're allowed to have so much on the workplace. So I don't think HIPAA comes into the effect when, you're legally taking that from a doctor's care. So I don't, the amounts may be different.
Thank you, Vice Chairman. I'm sorry, I was on a side. Was that question directed at someone in particular?
Yes.
Ms. Stroker, you recognize.
Sorry. So yes, you are correct. Yes. If you are, under the care of a doctor who is prescribing your medicine and telling you what you can and can't do and what the side effects may be, there could be parameters around the job you could do while you're using it and whatnot. This does not, as stated earlier, it doesn't have a doctor prescribing it. It doesn't have a doctor talking with them about the impact of the marijuana. And the bill specifically says everything in this section is HIPAA protected. So I don't think or know if we could even ask it or take action based on a potential drug test. Is what I'm saying is that it's unclear based on the two sections read together.
Vice Chairman Sexton.
Thank you. So what you're saying is, and I think this potentially could be a problem, what you're saying is that since there's not a doctor's prescription, you really don't know what the levels are or could be. All that the prescription would say that the doctor has diagnosed them with the condition. And so any level whatsoever they could use, I guess. Is that correct?
Ms. Stroker.
Potentially, yes, but the bigger question is, could we even ask? And that's kind of where, as the bill read together with those two sections kind of being a little conflicting, I don't even know if we could ask. And then that's kind of where the question comes in. But you're correct. There's no one telling them how much to take or what to take.
One follow-up.
Vice Chairman Sexton.
At some point, as with alcohol, they have certain guidelines that they go by. I see your point, and I think it's a valid point that there needs to be some guidelines that are put in place. Otherwise, you don't have a way of determining whether this person is impaired or not, maybe. So I think it's a good point. I think it's a very tough situation, but thank you.
Thank you very much to our panel from the administration. And we have more questions, so we'll stay as long as anyone likes. Leader Lamberth, you're next.
Sorry, Mr. Chairman, I will be very, very brief. And I was monitoring the conversation. I had stepped up for a moment. We're still listening. And I just want to be very clear in this question. I mean, the letter that is included within this is not a prescription, correct?
Ms. Stroker.
That's correct.
Leader Lamberth.
And if it were a prescription and a database that you could check, would that at least alleviate many of the concerns that you have?
For law enforcement, it would definitely help because they would have something they could go on, some type of guidance, some type of knowledge of what is okay, what isn't okay, and health may have some.
Mr. Powell.
From a health perspective, obviously, because there is so much still unknown about appropriate treatments with marijuana, a prescription is still very much up in the air because they're very unsettled dosing amounts and things of that sort. There's just not enough knowledge out there. It would not help with health, I don't think.
Leader Lambert.
I may be misunderstanding.
Hey, Mr. Chairman, I'm not asking whether or not you recommend a prescription. I ask from a legal standpoint, which is all this committee deals with, if a prescription was something that was authorized by state law and there was a prescription that was issued, does that alleviate a large amount of the concerns? Because there is a database, there is a list, there's a specific prescription that goes back to a doctor with a specific dose. Does that alleviate the concerns or most of them that you would have?
Mr. Powell.
I don't know that it would alleviate health's concerns. It may help safety's.
Ms. Stroker.
Yeah, it would definitely help law enforcement because they would have something to go off of. It would help in that little aspect of the problems presented here. Yeah.
Leader Lambert. Okay. Thank you, sir. I've put you on the list, sir. Next up, I have Representative Hardaway.
Thank you, Mr. Chairman. To safety, and this is back to the HIPAA question. Do you ask your officers now what prescriptions they are under?
And I'm
Ms. Stroker, you're recognized.
Sorry, I was looking back to the Colonel for definitive answers, but I know that obviously law enforcement is held to a very high standard, and we have zero tolerance policies for drugs and alcohol. And so I don't know the specifics of what we can ask and what we do ask, but I know we do a lot of drug testing, we do a lot of screening, but I can certainly figure out exactly what we ask and get back to you on that. I just don't have it right now, and I'm hoping somebody's watching and pulling it and texting me that information. But we do require a lot of information just based on the status of how important that job is to make sure somebody is not impaired.
Representative Hardaway.
Thank you. And are they required to self-report prescription drug use?
Ms. Stroker.
And that's what I just don't know right off the top of my head. I'm hoping I can find out while other people are testifying. But since we do have a very hard zero tolerance policy for drugs and alcohol, I'm sure there's something that we ask. I know in certain situations we require testing depending on your job, depending on a situation that may have happened. And yeah, I'm getting an answer that yes, we do. We do request that.
Next on my list, I have Chairman Holsey. You're recognized.
Thank you, Mr. Chairman. Maybe this should be to the sponsor, but since we're talking about law enforcement, I have a hard problem with this bill anyway, but I was looking at the practical side of it. Some patient goes with his letter to Colorado and buys some dope or in oil, let's say, and he's coming back and he gets pulled over in the state of Arkansas for speeding, and they run a dog around the car and he hits on this stuff. And the guy says, look, I got my letter right here from Tennessee, says I can have this. And the guy in Arkansas says, you're not in the state of Tennessee here. You're going to jail. What keeps any other state from not recognizing this little letter that the guy's running around with?
Ms. Stroker, for a review of the Arkansas Code annotated.
All right, let's change it and put another state. A more sane state.
And sorry.
Ms. Stroker, you're recognized.
This committee is always entertaining. I will give it that. It's always a joy to be here. To your point, that is where kind of our questions with the bill come, is how do we enforce it? Because we don't know if that person is telling the truth. We don't know if that information is accurate. And really, it would kind of just be on that state, what their laws are, and I guess figure it out at court. But
Next on my list, I have Representative Griffey. You're recognized.
Thank you very much, Mr. Chairman, and this one's for Ms. Stroker with legal. Ms. Stroker, let me ask you this, because I'm looking through the legislations as it's drafted, and it's going to say that it's not going to be an offense for a person who's a qualified patient or a qualified patient's authorized caregiver to have in that individual's possession lawfully obtained medical marijuana or paraphernalia designed to facilitate the consumption if the person meets these conditions. And then it says a caregiver means a person who is authorized by a qualified patient or the qualified patient's legal representative to obtain and possess medical marijuana on the patient's behalf. So let me just play devil's advocate here for a moment. If I'm a law enforcement officer and I pull somebody over, I mean, people want to use marijuana. They want to get high. There's a huge drug activity, illegal drug activity related to marijuana use. Suppose somebody meets one of these requirements to have a condition, but they want to use that condition to exploit and sell medical marijuana to people in Tennessee, and couldn't an authorized patient, couldn't that patient give out, maybe they give out 100 or 200 letters to anybody that they deem is going to be an authorized caregiver, and then that person has marijuana on their possession, they get pulled over by THB for swerving and reckless driving or something like that, and the person goes, oh no, I'm an authorized caregiver, I can have this much marijuana. Is there anything that law enforcement officers going to be able to do on the side of the road if that situation arises?
Ms. Stroker, you're recognized.
Yes, and I think the DAs can probably answer this when they come up in regards to how it may be a problem for the courts. But as far as law enforcement, let's say they pull that person over. But again, it's going to be, do they know what the laws are in that other state? Is this person really related to that person? You can't call and check with the doctor because the doctor's not going to disclose that information, especially if you're a caregiver, because it's not you, it's someone that you're caring for. And so that's kind of the problem that law enforcement is coming from, is that it's really difficult to enforce this because there are so many loopholes and inconsistencies with it that create those exact problems.
Thank you, sir. Next on my list, I have Chairman Doggett.
Thank you. I apologize for asking more questions, but you have to be a Tennessee resident for this to apply for this bill. Is it specific for Tennessee residents, or could anyone that's passing through from, let's say, Pennsylvania or Virginia or Colorado that maybe came here to a Titans game and had their card with them or their letter and well, I'm just saying, they come to Nashville to visit. It's a wonderful place to be. But I think it's a legitimate question.
Chairman Doggett, do you wish to direct that question to legal or?
I could, yes, please, sir. If
Okay.
we could direct that to legal.
If legal services has a response?
Under this amendment, a practitioner is a physician who's licensed under our Title 63, Chapter 6, or an osteopathic medicine licensed under our Title 63, Chapter 9. So the practitioner in this language would have to be licensed under our state. As far as whether or not someone can enter our state with a medical marijuana authorization from another state, that's not addressed by this amendment, and that is a whole different deal. Yes.
Chairman Doggett.
So would it be, would I be wrong to assume that they would be in violation of the law for someone that was coming from Colorado or Pennsylvania or Virginia or Michigan or wherever, that under current law, they would be in violation, but if this was to pass, Tennesseans who may have went to Pennsylvania or Colorado or elsewhere to get their medication would not be in violation of the law?
They would be in violation of Tennessee law if they were to come to our state with a medical marijuana authorization from Colorado. They would be in violation of Tennessee law because that's not allowed under our law. The practitioner who signs the letter under this amendment would have to be licensed under our Title 63, either Chapter 6 or Chapter 9. So for the language in this amendment to apply, they would have to have a letter from a practitioner licensed in our state.
Chairman Doggett.
Yep. Thank you. No more questions. Thank you.
Members, we have come to the end of our list for the administration panel. Thank you very much for being with us today. That brings us to the law enforcement panel, and on the list I have Mr. Jimmy Music from the Tennessee Bureau of Investigations, Zoe Sams from the District Attorney General's Conference, Mike Agee from the Tennessee Sheriff's Association, and Miss Maggie McLean Duncan from the Tennessee Association of Chiefs of Police. If you are here with us today, please come down front. You're well known to members of this committee. But if you could please introduce yourself for the record. Each of you will have 4 minutes to share with whatever you'd like with this committee, and afterwards we'll have unlimited time for questions and answers.
Even better.
When you talk. And I misspoke. I mentioned we had Zoe Sams, but we have General Crump with us today. So thank you for being here, sir. Who would like to go first? Okay. Sir, you're recognized.
I'm Mike Little. I'm Assistant Director of the TBI in charge of the Crime Lab Division. I'm clearly not Jimmy Music. I'd be happy to answer whatever questions I can regarding the DUIs and the toxicology testing of marijuana. What I came a little more prepared for was to discuss the controlled substance side of testing solid dosage drugs. And specifically in reading this bill, it had some things in here that confused me. It states that you cannot be in possession of 2,800 milligrams or more of THC, of tetrahydrocannabinol. What it doesn't specify is what flavor of THC we're talking about. As we have seen in the crime lab with past cannabis legislation, we've run into Delta-9 THC, we've run into THC acid, we've run into Delta-8 THC, and we're expecting to run into Delta-10 THC. So there's a wide list of potential THC compounds out there that behave differently, and some are more impairing than others. As far as the 2,800 milligrams is concerned, what we run into in the crime lab and what we've run into in the past with other cannabis laws is that in our attempts to enforce it, we really become default regulation. And as we've gone with hemp, we have to come up with quantitative methods to determine what this is. When you present to me a material and ask me if there's 2,800 milligrams of THC present, the first thing I have to do is determine what the concentration of THC is, and then multiply that times the amount that I'm given. 2,800 is 1/10 of a gram, so I'm not sure where we're talking about a half a gram or a quarter of a gram. But this would be a very huge lift for the crime lab to perform a regulatory function in these cases to determine quantitatively what each of these compounds is and then determine what the total THC concentration is that we're presented. That gets even further complicated by what items were presented. To test in a chocolate chip cookie versus a gummy bear versus an oil versus a lotion are all completely different. We have over the past year come up with methods for plant material. We're working on methods for oils. Over the last year, we've been presented with over 8,200 samples of plant material. And what we're finding is that about 85% of those are consistent with marijuana and about 15% of those are consistent with hemp. So to do this would add another facet of regulation to the crime lab that would be cost prohibitive in both people and in equipment. And I'll answer any questions later.
Thank you, sir. Who'd like to go next? Ms. Duncan?
Thank you, sir. Maggie Duncan. I'm the Executive Director for the Tennessee Association of Chiefs of Police. Chairman, I'd like to, and committee, we know that the sponsor's places in his heart's in the right place with his intent. As we are been graciously waiting for the federal government to address the rescheduling of this drug, we still see this bill is making an illegal drug legal. That presents a great deal of issues for us, and the fact that we obviously would prefer the FDA to take care of this because it puts us in conflict with what our oath of office is to enforce federal and state law. We can't just blindly not enforce federal law. Ms. Stroker has laid out several points for you. So in order to be brief, I will just add a couple others. We truly are concerned of how we will determine what 28 milligrams of cream, pills, oils, suppositories, et cetera, is on the side of the road. Please keep in mind that oils are vaped and oils can be added to food products. A letter from a doctor that we can't easily verify as valid can easily be forged. And therefore, are we expected to know all the state's applicable laws to verify if a patient or caregiver is in compliance? Because that's what our job as law enforcement officers is to enforce the law. A couple other things to keep in mind is that with the DUI piece in the bill, which we are grateful for, we also need to know if we are allowing someone to drive or possess a firearm when they're in our employment. We don't currently allow that to happen, and that would be a huge liability not only for the agency but for the local government, and could present a civil liability for the officer. There is no specific difference between medical and recreational cannabis. They are the same. They're the same animal. They're the same plant and what it's derived from. So keep that in mind. There's not a difference. Many of us have visited Colorado and other states that have this. And when you go, the difference is in how much you pay and what your taxes are. It is not that you're getting a different product. So I just put those things in front of you for your consideration. This bill, with the vagueness that's in it and our ability to enforce it, will become unenforceable and will put us in a bind. Thank you for your time.
Thank you, ma'am. General Crump?
Hello, my name is Stephen Crump. I'm the District Attorney General in the 10th Judicial District. I also serve as the Legislative Chairman for the District Attorneys General Conference. I will not repeat any of the information that's been previously given to you by my law enforcement colleagues, but I would say this from the District Attorney's perspective: this represents a policy choice for this body. We consistently try to evaluate things based upon what are those things that are purely within the province of the General Assembly as to whether or not something is in fact a policy choice or not. This falls within that. However, this is a circumstance where we have seen the drastic difficulties of of enforcement when you all make a choice as you did with hemp. Hemp became very difficult for law enforcement to deal with. It also became virtually impossible for us to prosecute on the criminal side. When I look at this, when I look at this bill, it raises the same very specific questions. We do not, where we will be forced to choose is to try to determine who is the person who is a lawful person who desperately needs this medication and who is using it not for purposes that are wrong, but for the right purpose and for hope. The problem will be, it will be impossible for an officer on the side of the road or somebody, to go back to Chairman Doggett's question, if somebody flies in here from some other place, this bill will cover them. You cannot simply restrict this protection to a Tennessee resident from an equal protection perspective. We will be required to look at every person that comes in here. The enforcement under trying to figure out who is a qualified caregiver, who is a qualified practitioner in another state. Did they have an actual assessment when they were in that state? How often are they assessed? All those are questions that first a law enforcement officer will be required to deal with on the road, and then secondly, we'll be required to deal with in our criminal courts. While this is a policy decision that you all have to make, we stand with our law enforcement friends and say, until there is a vetting of these substances by the FDA, until we know that procedure, until it's gone through that procedure, until there are ways in which Tennessee law enforcement can deal with this in an effective and fair manner, and until there is a regulatory scheme that is put in place to control the use of this and assist not only law enforcement, but Tennessee medical practitioners in determining how this substance should be used, when it should be used, and who should use it, then we cannot be in support of this bill. And as my colleagues have said, we recognize that this bill comes from a good place, and we don't want to stand in the way of that, but we do feel like it's important that we raise what we believe are significant issues and questions with this bill.
Thank you, sir. Next on my list, we have Mr. Agee.
Thank you, Mr. Chairman and committee. I will be very brief. And Mr. Chairman, if I seem distracted, there is a red laser light right here, and I hope somebody doesn't have a gun pointed at me. But I don't know what that is. This is a tough issue, and we don't envy the position you're in. And this is a tough issue for us. It's an emotional issue because we have friends and family that have many of these diseases. But at the end of the day, we are sworn to uphold the law. And you have heard people much more intelligent on this subject than I speak today, and I'm not going to repeat what they've said, but we are sworn to uphold the law. We struggle with the term, and we have the utmost respect, as has already been said, for the sponsors both in the House and the Senate on this bill. They've carried many bills for law enforcement. But we struggle with the term medical when the only involvement of a doctor is to sign a piece of paper to say, I have a disease. And he doesn't even have to know why he's signing it. I don't have to tell him. And there's no pharmacist involved in this at all. I go to the dispensary, they give me whatever, and I may or may not know what's in it if I'm administer it to a family member or whatever. We appreciate the intent, but the way this bill is structured, we think that it would be virtually impossible for us to enforce and to be able to determine between who are the people that are using this for the right purpose from the ones that aren't. So with that, I thank you for your time and your attention.
Thank you, sir. Members, do we have any questions for our law enforcement panel? Seeing none, thank you for being here. Oh, I'm sorry. Representative Sherrill, you recognized.
Thank you, Chairman. Just a comment, not really a question, but and things that's going on in our society today we see it all over the world, and especially in the United States, things that's going on with especially our law enforcement officers. I just want to stop and say thank you to all of our law enforcement officers that are here today. We appreciate every one of you and what you do, And we want to say very much appreciated to our law enforcement in the great state of Tennessee. We have a great bunch, and we need y'all, and we want you, and we want to try to protect you. And this is a very serious situation, and being in law enforcement, and if we were to pass this bill, it would be hard for a law enforcement officer to know what to do in a situation if this was in a car that you stopped. And I'll have to say that, not trying to pass this off to the federal, there's a lot of problems in the federal up there, but I think if we were to pass this law here in Tennessee, we'd be getting the cart before the horse, if the old saying is. So we appreciate you, law enforcement officers and the DAs and TBI and everybody. So thank you.
Thank you, Representative Sherrill. Next on my list, I have Chairman Farmer. You recognized?
Yeah, thank you, Mr. Chairman. I don't know who this may be for, but currently, if an individual's been pulled over, and I'm sure this has happened many, many times, with an oil, vape, or rub or something in their car, how's it tested and what's the procedure currently?
I guess I'll take that one. From TBI's perspective, when we get presented with a vape oil, for example, we don't have a test to determine quantitatively exactly what that amount is. Fortunately, what we take advantage of is the fact that if you're having an amount that's going to be abused, it's probably way greater than 1%. So we're able to compare that to a 1% standard and just tell you that it's greater than 1%, which is far greater than the 0.3% designated in the law. So we're able to tell you, yes, this is consistent with a drug to be abused, or yes, it's consistent with something from hemp.
Chairman Farmer.
And following up for that, once that's sent back to the district attorney's office, how is that prosecuted currently?
Mr. Chairman and Chairman Farmer, it would depend upon what the report said. It would depend. There are two basic things that we look at. One is the 0.03, one is the 0.09, which is the current medical amount that is there. And if it's above 0.10, then that's typically where we would look to prosecute. There have been circumstances where there have been some hemp stores that have advertised actually on their packaging greater concentrations of THC than was allowed under the law without a doctor's authorization under those statutes. We have prosecuted those as we prosecuted either as selling something that of a designed amount that it didn't meet up to, criminal simulation, or we did it as possession.
Okay.
Chairman Farmer.
And I just wanted to ask that. I just wanted to see if whether or not there was precedent to move forward and prosecute an individual with this that may not have doctors the note or the proper paperwork, and it sounds like there is. So thank you so much.
Thank you, Chairman Farmer. Next on my list, I have Chairman Doggett. You recognized?
Thank you, Mr. Chairman. I'm going to direct this question to the gentleman from TBI from the lab here. The 2,800 milligrams, would you not be able to determine that by maybe if it was in pill form, like some medications in pill form come in 750 milligrams or 1,000 milligrams or something like that? Would it not fit under that, or is there something?
So let's say
different?
that you have a pill, and let's say that pill weighs a gram. Well, that pill may be 50% the drug that you're interested in. It may be 50% other inert substances. Till we determine what the concentration of that drug is and then multiply it by the total weight, we won't know how many total milligrams of THC are present. So the first step that we would have to do in all of these cases is determine quantitatively what's the percentage of THC, and then multiply that times the total amount of sample that we're presented with. And again, to make that more complicated, THC is a vague term as presented here. We have seen carboxy THC, we've seen THC acid, we've seen delta 9 THC, delta 8 THC, delta 10 THC. So we're going to need some clarification on that before we can even proceed.
Chairman Doggett.
And so you're saying it's a little bit more complex than just ibuprofen that's 1,000 milligrams of ibuprofen.
Right. And even with ibuprofen, I can't just weigh a pill and say it weighs 1,000 milligrams and tell you that you have 1,000 milligrams of ibuprofen there. There are going to be other things present in that other than the active ingredient.
Okay.
Chairman Doggett, any follow-up?
I do, yes, sir. which if you, again, if you can't determine that amount, I was trying to see what the correlation was between 2,800 milligrams of this and a half an ounce of, for simple possession purposes, that we normally have. I'm trying to get that correlation, but if you can't determine that based off
Right.
of what's in it,
It would
couldn't answer
depend
that
on the
question.
concentration. A half of an ounce is 14 grams. If it's 10%, then it'd be 1,400 milligrams. If it's 20%, it'd be 2,800 milligrams. If it's 30%, it would be whatever 3 times 14 is. So we have to first know that concentration because you can't tell looking at it whether that oil or lotion or whatever is 10, 20, 30, 40, 50% THC.
Okay. Thank you, Mr. Chairman.
Thank you, Chairman Doggett. Members, I have no one else on my list for the law enforcement panel, so thank you very much for being here today. We appreciate your testimony. That brings us to our testimony in favor of this legislation. I have on my list a man who's very familiar to this committee, Representative Bob Ramsey, Chairman of the House Health Subcommittee. And then I also have Holly and TJ Ramsey here. And if you all could make your way down front. I know you've been waiting patiently, and I appreciate that. Thank you all very much for being here. Whoever would like to go first, if you could just state your full name for the record, and then share with this committee whatever you'd like, and you have 4 minutes.
Okay. Hi, I'm Holly Ramsey. Thank you for your service to our state. My dad is a veteran from Tennessee. My uncle retired from the Metro Police Department. My aunt was rape and homicide detective and officer of the year here in Nashville. My grandfather is a judge here. My husband, who is originally from Greenville, Tennessee, is the COO of the Nashville airport. They seize hundreds of pounds of marijuana every year. I understand what this state is going through. And this state is important to us and to our family. We have 3 children who are here with us. And one of them is suffering in a way that only you can help us with. Because we love Tennessee, because I believe in the mission of the police department, because we clearly understand, and my husband clearly understands the issue that marijuana has presented in this state. That's why I'm begging all of you to help him. This is TJ. TJ is the 3rd grader at Scales Elementary School. TJ has cerebral palsy, but that's not what limits him. In fact, it actually makes him faster because now he has wheels. So it's pretty quick with those things. TJ has refractory epilepsy. He has suffered from as many as 22 seizures per day. Since we've been in this room, he's had 3. Okay, that you all have seen. He has spent 4 week-long stays at EMUs at 3 different hospitals, and he has seen the most specialized doctors in epilepsy that pediatric neurology has to offer. TJ has decided to appear today as Cyborg Spider-Man. He's always some form of superhero. Cyborg Spider-Man is in honor of the VNS implant that he had implanted about a year ago that is designed to go up through his vagus nerve and stop his seizures. That device has been there for about 2 years. He's tried 13 anti-epileptic drugs, or AED. And for TJ, the side effects of the AED is worse than the seizure. In fact, after the last hospital stay, we were advised that we had exhausted all of the current classes of anti-epileptic drugs, and we should look at CBD oils and medical cannabis. And this was from a physician, the leading epidemiologist in this state out in Memphis. Of course, he advised us we'd have to go to Arkansas to do that. I'm not going to go to Arkansas to do that. Okay, I'm not moving. We love being here. Well, we can use enough AEDs to control his epilepsy, but when doing so, we will lose him completely. And you see a lot of children that's the only choice their parents have to make. They got to drug them so much to stop the seizures that they lose their personalities. And hey, for those of you who've met him today, you know that's not an option. We're not losing that personality. So in 2014, TJ has CBD oil ready to take the minute that the Senate Bill 2531 was signed into law, and that almost stopped his seizures completely. And again, Tennessee led the FDA in that. Tennessee legalized our opportunity to use that CBD oil before the federal government and also before the FDA had approved Epidiolex. I can talk more about that if you want later. But when he took it, he had gotten a bottle from the Stanley Brothers that was older. I'd been sitting on my shelf for a month waiting for the legislature to pass. And when he took it, it stopped the seizures for 2 months. When we went back and ordered a second bottle, the hemp laws had come into pass. And so the limit went from an undisclosed low amount of THC, inert amount, to a specific amount of 0.03. That difference of 0.05, which is what we estimated was in the first bottle, to the 0.03, made it completely ineffective for TJ. And that's not uncommon with medications. A slight change can make a huge difference in its efficacy. Epidiolex is an FDA-approved CBD, and we have tried it. It's processed, it's clear, it has a sweet strawberry flavoring to it. Plant-based CBD is brown, and it tastes like, what do you think it tastes like? What? But we tried Epidiolex for several months because I don't quit easily. Eventually, we went back to the plant-based CBD oil, which is at least taking the edge off the seizures, even if it wasn't stopping them. There are 3 FDA-approved synthetic THC drugs on the market, which target nausea in patients. And we found that synthetic THC combined with Epidiolex still does not prevent the same therapeutic effect as the plant-based extract. And we believe that is due to the synthetic nature of those medications omitting the plant's terpenes. So the plant itself provides a medicative property. Having the additional medical tool of cannabis in oil form, or whatever form we can get it to help him, available to children suffering daily from a condition that limits their ability to participate in their own lives would be a blessing to so many families. This bill gives law-supporting families the opportunity to treat our sick children and protect their safety. Because I mean, maybe I could drive right now down to Mississippi and buy some tincture and bring it back, and I probably wouldn't get caught. But I wouldn't do that because I'm a law-abiding citizen. So that is who this bill is going to protect, the ones of us that believe in the law and support the law and want to have a conversation with our physicians who want this to be part of the medical record and part of the medical making decision for our children. So thank you for being a real-life superhero to all those people who need you the most, these kids who can't do it on their own, and the parents who will give anything to help them.
Thank you, ma'am. Thank you, TJ. Chairman Ramsey, you recognize?
And thank you very much, ladies and gentlemen, Mr. Chairman. I'm not a member of this Ramsey family, but I would certainly be honored to be TJ's brother and be Spider-Man too. But a wonderful story, and I appreciate the courage that brings you here. The reason I'm here, our sponsor is an excellent sponsor, very diligent, very capable, and I'm not here to support him. I'm here because I had a bill similar to this that was brought to me at the first of the year, House Bill 239. It came to me from Doug Gunnell's family. All of you recognize him as our liaison with TDOT. And it was for his son, Corey, who at 43 has passed away after a 10-year battle with neuroendocrine carcinoma. The day he passed was the day that we heard this bill in full health and was passed on to this committee, but didn't move in the Senate, so we didn't go any further. He left 2 children and a grieving family. And we asked him during the process, would he let us name the bill after him, Corey Gunnels? And he said no. He said, this bill is not about me, it's about the people. He said, this bill, he said, all I want to see is something good come from this struggle that I've had for 10 years. And the bill that you see before you would have served Corey's needs for a more peaceful resolution. And let me make clear that resolution doesn't mean cure. I mean, the folks that need these things fully understand what the situation is. 880 is a better bill than the one I had. 239 is a better bill than John Wayne Wendell's service-related veterans bill, and it helps more people. It has 11 diagnoses instead of one. It provides access to more products, not including smokable or vaping products. And there are many questions here answered today, a whole lot more than we got answers for, but the answers are in the other 40 odd states, I'm told 44, that have already dealt with this issue. And the beauty of this bill is it requires the Department of Health and health-related boards to perform a study on licensure and regulation of cannabis for medical use and study the impacts on providers and patients as we go forward. The bill is about access to patients, not growers, not infrastructure, but at some time we're going to need to address those issues in Tennessee as one of the last states to consider the issue. This is a bill about people. The federal government has no magic wand that over 40 states have ignored. We always want to fall back on, well, I'm going to wait on the federal government, which this is a rare case that we do that. And all the questions have answers. This bill initially asked the Department of Health to get those answers from other states before December 2021. Now, it's my understanding that you have been sent a lot of information highly misrepresenting the congressional report on medical cannabis in 2017. That was done by the National Academies of Science, and the congressional report summarizes the last 20 years of research, which is very sparse. And it makes cautious statements which were misquoted in information that you were given in your material. One of the 16 members of that task force, Sean Hennessy, a professor of epidemiology, in 2019 addressed the Congress about that issue. The most of the findings were noted by the terms limited or moderate evidence, and the material that you were given alters those labels and has maybe, no good, and harmful on there, which don't exist in the report. The quote also questions the directionality of some of the issues and notes the regulatory barriers to federal scheduling because of federal scheduling and restricted access to quantity and quality. It notes the network of funders.
Chairman Ramsey, I apologize. I have to call time, but if anyone has any questions for Chairman Ramsey. Yeah, okay. First on my list, I have Vice Chairman Sexton, and Vice Chairman Sexton, you're recognized.
Holly and TJ, right? You've sat through all of the testimony today. That's correct. You've been here the whole time. And you've listened to the concerns that law enforcement, safety, everyone that's had, right? You have tried some of these different oils and things for TJ. Is that correct?
Yes, sir.
Two questions. One, did you use them illegal?
No.
So you went to the state where they were legal.
Well, the first bottle that we received was from a state where it was legal, and at that time there wasn't a way to, it was in 2014, so the one that worked was from a state that was legal, yes.
Vice Chairman Sexton.
My question is very simple. After hearing all the testimony and all the challenges and problems with this bill, if you were sitting on this panel, would you vote for it?
Ma'am?
Yes, because people who do not follow the law and will find loopholes around the law will find loopholes around whatever law you write. This law protects those of us who are law abiding and who need an opportunity to be protected to take care of our children.
Vice Chairman.
It's a pretty good answer. So you're looking for something for your son that will make it legal for you to continue to be the law-abiding citizen that you are.
Yes.
And you think it's worth all of the problems that you've heard today. You think it's worth taking all of those challenges to help your son.
I do. And I think there's other children just like him who it's worth it for them too.
Thank you.
Thank you, Vice Chairman Sexton. Next on my list, I have Representative Lamar.
Thank you, Mr. Chairman. And I just want to say thank you for your testimony. TJ is just absolutely adorable. And, I hope the committee votes in an affirmative to help you and your family. I had a friend who in college slipped in the bathroom and hit her head, and she got epilepsy. And she was having seizures, and she lives in a state where it's completely recreational, by the way. And they prescribed her medicines, and she was still having seizures. She started using marijuana to help her stop having constant seizures. I mean, she was falling out in class, having seizures. One time she was walking to class on campus and had a seizure in the middle of campus, and she doesn't have them anymore. She has a healthy baby boy and is living her best life because of many of the advances that we have been able to make using marijuana to really curb some of these diseases. So I've seen it firsthand to the people closest to me, how this can help cure many of the listed issues that were stated in this bill. So I understand your need. I've seen it work, and I hope that the committee votes in affirmative support you, TJ, people like my friend and other folks around the country who could use this and don't want to use opioids to cure that.
Thank you, Representative Lamar. Ma'am, I just want to thank you for being here today. I think what I hear you saying is that locks are for honest people. That's what my dad used to tell me when I was a kid. And I don't think from where you sit, you really care if anybody else decides to break the law. That's not what you're deciding to do.
Correct.
You wish to follow the laws of this state, and we appreciate you and many, many others like you. So thank you very much for your testimony today. In my own district, I've had several friends with firsthand experience. I have a dear friend who unfortunately is no longer with us. He was a physician himself, but he was diagnosed with brain cancer. And for a long time, he was bedridden, was unresponsive, unable to speak to his children or his grandchildren or his wife. But with the use of marijuana, suddenly he got about the last 6 months of his life back, and was able to get up, move around his house, go to restaurants with his grandchildren. Now, he was still very much a sick man, but it helped him with his symptoms. And I had many conversations with him during that kind of twilight period of his life. And I can say that he advocated very, very strongly for Tennessee to get its act together in this regard. So thank you for being here today. Thank you for allowing us to visit with TJ and for sharing him. I know this room is cold and you've been here a long time. And I know that costume's not very thick. So thank you for being here. Any other questions for our witnesses? Representative Hardaway, you're recognized.
Thank you, Mr. Chairman. I can't resist the opportunity to speak to TJ, though. And I want to thank TJ. I want to thank you for being here, man. You're doing that superhero bit, and that's the kind of thing that Spider-Man would do. Show up and save the day. So thank you. Anything you want to share with us, Mr. Chairman? Mr. Chairman, would you recognize TJ?
Absolutely. TJ, anything you'd like to share with us today?
All right, very good.
Yeah.
Ms. Ramsey, I appreciate the difficult position that you're in, and I would just suggest to my colleagues that if somebody's going to have problems, let it be the DA, let it be the THP, let it be TBI, let it be us. But our job as legislators is to look after TJ and folks who have the issues that TJ have, and to help the parents, the fathers and mothers like Miss Ramsey to look after their children, to make decisions in their best interest. This bill is not merely about reforming criminal justice. This bill is about reforming health justice also. With that, Mr. Chairman, I want to thank TJ again and thank Ms. Ramsey for being here.
Thank you, Representative Hardaway. Any further questions? Seeing none. Thank you again for being here. Members, that brings us to the end of our folks who've requested to testify. So we'll go back into session. We're back in session. That means we are back on the bill, which is House Bill 880 by Chairman Terry as amended. I do have a list going for folks who want to ask questions on the bill, and I'll work my way through that as quickly as possible. So first on my list, I have Representative Hawk. You're recognized.
Thank you, Mr. Chairman. It is impossible to remove emotion from the issues that we debate down here. In fact, emotion drives much of what we do, and we are not immune to this emotion, but we must balance practical application with these feelings as we look to craft the best policy that will be enacted for all Tennesseans. As I look at the practical application of this legislation, I hear concerns from many folks. I hear support from many folks. But at this moment of this discussion, Mr. Chairman and members, I move to send this bill to summer study.
That is a proper motion. It does have a second. It is a debatable motion. Do we have any debate on the motion to summer study? First, I have Representative Lamar.
Thank you, Mr. Chairman. My only comment before we decide to do that is that, you know, over 36 states in this country, if not more, have either legalized, complete recreational, medical, or decriminalized marijuana. We've stated earlier, the federal government isn't taking any action on any state that is making those decisions, including the states in the South, such as Missouri, Arkansas, Mississippi, Florida, Georgia, if I'm not mistaken, Kentucky, if I'm not mistaken. This is a good opportunity for us to test this out. This bill is so limited in its scope. And sure, it's not perfect. It's not perfect in any of the other states across the country. But let's use this opportunity to figure out how we're going to get used to this before the federal government opens up the floodgates. And it's taken off and we're opening it up for complete use, yet we've never had an opportunity to handle this in our state. This is a very limited opportunity that is being used to help individuals who have health issues. This is not decriminalization. This is not recreational. This is not a free pass for anybody to go get high and smoke weed. I promise you it's not. The data shows that this could really help those individuals who are sick and suffering from the listed medical issues in this bill. And this is an opportunity for our state to pilot how we're going to handle marijuana before we are forced to handle it by the federal government. So let's give ourselves the opportunity to say that we took the first step and not the Biden administration taking the first step on Tennessee. Let's do this ourselves. And this is just a very limited way to do that. So, you know, I hope that we can reconsider to go ahead and pass this and allow us to help these families, like we heard earlier, and not be forced to make the first step by the federal government. And thank you, Mr. Chairman, for letting me make my comments. And thank you, committee.
Thank you, Representative Lamar. Next on the motion for summer study is Leader Lambert.
Thank you, Mr. Chairman, and I would support my colleagues' motion for summer study at this time. And there are multiple other vehicles out there that would do this. I commend the sponsor on the work he's done. It is 99% there. The one thing this bill is missing is an actual prescription by a doctor. There is no reason in the state of Tennessee why we should not literally impose our 10th Amendment rights on the federal government, not wait for the federal government, but free our doctors up to help TJ and everybody else and genuinely guide them through the medical decisions. I have spoken on these type of bills over and over and over again. This bill legalizes these substances that have THC, and we have heard the testimony today. It will legalize any oil in any car anywhere in this state because they can't tell the difference. There's no way to tell on the side of the road if it's 2,800 milligrams of THC. It is an impossibility. That's the testimony we've heard. Why not take the shackles off of our patients here in these particular circumstances and free our doctors up to prescribe these patients the exact dose, the exact amount, the exact time frame on what medicine they need. I've studied this for a decade as part of the legislature and just personally with friends and everyone else and folks in other states. In other countries where this is handled as actual medical marijuana, which is what the sponsor is headed towards, and I trust him more than anybody else on the planet to get this right, a prescription is how this is the best handled, where a doctor and a patient can actually make that determination together on how. PTSD is included within this. The studies are all over the place on the effect of THC on someone that is suffering PTSD. In some instances, it can help. In other instances, it can have disastrous effects and severely worsen the condition. That's true for many of the illnesses that are in this. So we're not the health committee. That's for others to decide. But from a legal standpoint, this is not there yet. A prescription solves all of that. I'm not asking for us to wait on the feds. I'm asking us for us to step up and just go ahead and say, from a state law perspective, every single one of our doctors can prescribe the medication that they feel is necessary, even if it includes THC. And I will go a step farther. I don't think we should control what type or version that has. If a doctor feels like someone should have green leafy substance, THC, or something else, if that is a doctor and a patient making that decision, and the doctor is willing to stand behind that based on their medical oath, based on what science has said, then the laws of the state of Tennessee should not get in between a doctor and a patient. This bill doesn't do that yet. I am still waiting for that time when we have a bill that will say, yes, a doctor can prescribe TJ or anyone else the medicine that they need. So that's the reason why at this juncture, I would support a summer study. I appreciate the motion to do so. I think that is most appropriate. However, there are other vehicles out there this year, and we are still in session. So there is no reason, if this motion is successful today, that we can still not continue this conversation over the next few days and weeks before we adjourn this session. But if we are not able to do so, then absolutely, I feel like this is something we have to get right over the summer, and we genuinely study it. Thank you, Mr. Chairman.
Thank you, Leader Lamberth. Next on the list for the motion to summer study is Vice Chairman Sexton. You recognize.
Thank you, Mr. Chairman. This is such a difficult thing. I agree wholeheartedly with both sides. I go back to something that Representative Hardaway said. It's on us. And what's on us to decide is whether or not that we give individuals the freedom to, for lack of a better term, the right to try. You've got the element of the law, and what do we do? I don't know whether it's proper, Mr. Chairman, but I would like for us to do something that keeps it going. If that's summer study and we can study it over the next few days and maybe come to a conclusion, something should be worked out for TJ and the people like him, that we don't continue to hinder their ability or their right to try. I don't know what that is, because I too want to be law-abiding and I want to be safe. And I don't know if there's any regulation, any rule, or any path for us to get there, but I feel the need to do something. I feel the need for us to not let it die. I have great admiration for Dr. Terry. I know his heart, and I know why he's doing it. or at least I think I do. And I also know those on this panel that have the concern to get it right. I know their heart as well. But when we see people like TJ and others, we have to find a way. And we need to find a way to make it work. So I apologize because I don't know what the answer is, but I'm asking if there is a path or a way for us to get there.
Thank you, Mr. Vice Chairman. And I'm actually wanting to speak up on this as well. I mean, the notion of summer study, I respect the spirit in which it was given. I'm reminded when I came into this body as a freshman, there was a summer study done on medical cannabis and marijuana at that time. Several meetings took place. They were lengthy, and there was a lot of testimony from a lot of the folks that we heard from today and even more. Moreover, this bill in the first section calls for a study within the bill itself that we're talking about. We cannot wait, and I agree with you, Vice Chairman. I agree that something needs to be done on this. I could not more vehemently oppose the motion to summer study, and for that, I move that motion to the table, and the parliamentary procedure is that cuts off all debate except for that of the sponsor. You're recognized.
Thank you, Mr. Chairman, and thank you for the debate that we've had. I respect everyone in this committee. I'll say this about myself. I quite often say I'm a jack of all trades and master of very few. I don't know everything about these issues. I don't know everything about this particular issue. But I do know that the medical community needs to make these decisions. When you leave these decisions based to politicos, we may or may not get it right. I want the doctors to decide this on a broad level, on a highest level at the FDA. I want those discussions to be had. That is what's going to move this particular issue forward in our country and in our state. You've heard testimony from the governor's office. It's coin flip right now whether if we do anything legislatively or not, if this bill ever gets signed into law, period. I understand the need and the desire and the emotion behind this issue. We are not cold-hearted. Everyone in here has listened very attentively to this discussion. I've got folks back home that are have strong feelings on both sides of this issue. You can't get beyond that. But as was said earlier in this committee by one of my colleagues 3 seats down, this is the Criminal Justice Committee. Lady Justice has a blindfold on. And we have to take 2 pieces of paper and decide, is this right for Tennessee or is this not right for Tennessee? We're not trying to kill any bill. We're trying to have conversation throughout the summer. It may even be that we engage the Speaker of the House to put forth an in-depth conversation about this. I think he would be willing to do that in public, in this room right here, and we have broad discussions about that. I would encourage folks to vote no on the tabling motion as we move forward on this legislation. Thank you, Mr. Chairman and members.
Representative Griffey, you're recognized for a parliamentary inquiry.
Thank you, Mr. Chairman. When we vote, will this be voting in favor? If we vote yes, we'll be voting to table the motion. If we vote no, we table it. Then we'll come back and still vote on the motion for summer study. Is that?
No, sir.
correct?
The parliamentary situation we find ourselves in is that Representative Hawk moved a motion to summer study. I moved that motion to the table. That cuts off all debate except for that of the sponsor of the motion. We will then vote on the tabling motion. If you're for tabling, you would vote yes. If you're against the tabling motion, you would vote no. At that point, if the yeses prevail, we are back on the bill as amended. If the noes prevail, the tabling motion fails, and we will be back on the debate for summer study.
Okay, thank you. Thank you. Thank you, Mr. Chairman.
Thank you, sir. So without objection, we are ready. Representative Griffey, you recognize.
I do apologize, Mr. Chairman. Could we do it by roll call vote?
The tabling motion cuts off all debate except for that of the sponsor. He has closed, and now we must vote. Thank you.
Thank you, Mr. Chairman.
All those in favor of the tabling motion say aye. Aye. Those opposed? No. The ayes have it. We're back on the bill. Leader Lamberth, you recognized?
Mr. Chairman, may we take 5 or 3 minutes?
The request for a recess is granted 3 minutes. Thank you very much for your patience. We are back in session. During the recess, I conferred with legal services, and I would like to go out of session for a moment to address legal services on a question that was brought up during debate. So out of session. And the question is, there was a recommendation made that another vehicle or this vehicle be used to create a program or a process whereby a Tennessee physician can write a legal prescription for marijuana. And you had some counsel for me while we were out of session. If you could please speak to that.
Michelle Fogarty, Legal Services. A physician in this state could not legally write a prescription for marijuana without violating federal law and therefore risking the loss of their DEA license to write prescriptions for any substance at all. In states that allow medical marijuana, physicians make a recommendation for medical marijuana, but they do not write a prescription because doing so they could lose their DEA license because it's a violation of federal law. And the Ninth Circuit, a case out of the Ninth Circuit did uphold that in deciding that a physician's discussing the potential benefits of medical marijuana and making such recommendations constitute free speech under the First Amendment. So the Ninth Circuit has upheld that. But just generally speaking, a physician cannot legally write a prescription for medical marijuana because they would be violating federal law.
Okay, thank you. That was advised to me during the recess, so I wanted to make sure the committee heard it. I have several on the list to speak with legal services, I presume. First is Representative Griffey. You're recognized.
Thank you very much, Mr. Chairman. I'm not sure if legal services know this or not, or one of the other speakers that we had here. It's my understanding that there already is a THC pill available that physicians can legally prescribe to patients for certain medical conditions. And and we talked about prescribing medical marijuana, that may not suffice, but we could perhaps write an exemption that if someone has a prescription for a THC, then they might not be prosecuted for an offense of having marijuana for one of these listed conditions or something. That was sort of my thought, because it seemed like to me the problem is we've got a law that criminalizes possession of marijuana. And maybe rather than going about it this way, for me, the problem with this way is that we're creating sort of a marketplace for medical marijuana and those products.
I'm sorry, Representative Griffey. I'm more than happy to recognize we're back on the bill. If it's a question for legal services, that was why we're out.
The medical marijuana pill prescription would be my question for legal.
Okay.
If that was an FDA-approved drug, then I assume that a physician could write a prescription for, but I don't know. I don't know off the top of my head whether or not that would be an FDA-approved drug.
Yes, sir. Next on my list, I have Chairman Doggett. You recognize?
Thank you, Mr. Chairman. For legal services, you stated that if a doctor was to prescribe this, that they would be in violation of federal law. Is that correct?
Yes, sir.
My question is this bill as written a violation of federal law?
Well, under federal law, possession of marijuana is illegal. So a person who is possessing marijuana, even under this bill, would be violating federal law.
Chairman Doggett.
And so one way or the other, could we not, with that theory, amend it to where it was by prescription instead of through a recommendation from another state? If we're still in the same posture, we're still violating federal law one way or the other, could we not do by prescription instead of just, and I think that would give more, it would put up more guardrails around this and contain it maybe a little bit more in a box.
Any physician writing a prescription for marijuana would be violating federal law, and they could potentially lose their license from the DEA to write prescriptions for anything. So even if you pass this law, they would still be violating federal law and they would still risk losing their DEA license.
Okay. Thank you.
Thank you, Chairman Doggett. And I think the difference would be the physician would lose their license, not be able to make their livelihood. If we pass the bill as amended, the person is not in violation of state law and not likely to be prosecuted by the federal government. I think is the distinction between the two, not advocating one way or the other. Next on my list is Leader Lamberth.
Thank you, Mr. Chairman. And I think you both relatively made the question I was going to ask legal, is that this entire thing is in violation of federal law, the entire bill. And I know you're giving us the best legal advice you can, but is it fair to say that right now, if a state taxes marijuana, if they, legalize marijuana, if they commingle funds that they take in taxation or, and mix that with state dollars, all of that is currently in violation of federal law, and states have done many of those things, and the federal government has not enforced federal law against them as a general rule to this juncture. Is that fair enough?
Yes, those are state actions, but this would make the physician would be violating federal law by writing the prescription, which I think is the distinction I was trying to make. The physician himself would be violating federal law.
Leader Lambert.
Yes, and I know this is a very difficult and tough question for any lawyer to answer. But again, the states that have legalized and have taxed marijuana are in violation of federal law, and the individuals that are possessing marijuana in those states are in violation of federal law, and the individuals and businesses that are selling marijuana are all in violation of federal law in those states that have legalized currently. Is that an accurate depiction? And the feds have not prosecuted them. Yeah, Mr. Chairman, it's okay. Look, it's fine. It's an extraordinarily difficult legal issue. Pass. Thank you, Mr. Chairman.
Thank you, Leader Lambert. Next on my list, and I just want to make sure, Representative Martin, was your question for legal services? Yeah. Okay, you are next on the list. You're recognized.
Thank you. My question for legal is, say, for example, if we were to pass this bill, is it up to the federal prosecutor's discretion to hold them accountable? So say, for example, there's obviously states across the country that have allowed medical marijuana, and we're saying it's still federally illegal. Say, for example, a federal prosecutor here wanted to, and we passed this bill, wanted to come after a physician or something like that. Could they do that? If that made sense.
Whether or not to prosecute would be a decision within the prosecutorial discretion of the federal prosecutor. A DEA licensure is within the realm of the DEA. So I guess it would be up to the DEA to decide whether or not they wanted to revoke a physician's license or ability to write prescriptions.
Thank you.
Next on my list, I have Vice Chairman Sexton. Again, I want to make sure, is a question for legal services? Okay, you're recognized, sir.
If we pass a law that says physicians can write a prescription for marijuana in Tennessee, and it's against federal law. So the problem is getting that doctor to write that prescription because they're afraid they'll lose their license. Is that correct?
A physician's ability to write a prescription is based on licensure from the DEA. So if a physician is not licensed by the DEA to write a prescription, then he can't write a prescription for anything. So if he writes a prescription for marijuana, he is violating federal law, and under the DEA regulations, he could lose his licensure to write prescriptions.
And who is the DEA?
The Drug Enforcement Agency.
And that is federal.
Yes, sir.
So he gets his license from the federal, and he would lose that. Is that correct?
There's the potential for a physician to lose his DEA license.
Next question. Do we have states that are violating the DEA? Do we have states where doctors are writing prescriptions and violating the federal law?
It's my understanding that in states that have allowed medical marijuana, the physicians make a recommendation. They do not write a prescription for. marijuana.
Okay, I understood that a while ago, but my question is, to your knowledge, there's no doctors writing prescriptions for medical marijuana.
I have no way of knowing that.
Okay, to your knowledge. I think that's all. Thank you.
I have others on the list to ask questions of legal services. Okay. Okay. Next on my list to ask a question of legal services is the sponsor, Chairman Terry. I'm notified by the clerk's office that that is allowable, so you are recognized.
All right, thank you. And I've got 2 points to make and try to get clarification on this. One of the questions was, as far as violating federal law, this bill is decriminalizing the possession and prosecution in the state of Tennessee. And when we talk about violation of federal law, we have already passed something that the state will not enforce that. It's Public Chapter 380 dealing with firearms, says that we will not use our personnel, our property, or funds if that violates state law, Tennessee Constitution, or Tennessee common law. That's already in our statute. And that's one of the reasons why I referenced that in the bill. Secondly, I do have an AG's opinion from our AG, and it says the U.S. Drug Enforcement Agency, which is part of the Department of Justice, has not made it a policy to suspend or revoke the authority of physicians and pharmacists to prescribe or dispense controlled substances under federal law as a result of medical professionals' participation in a state medical cannabis program. The DEA did revoke the prescribing authority of a Colorado physician who had prescribed medical marijuana to an excess number of patients, but it justified the revocation as a result of Colorado's suspension of the physician's license. I can come back to that issue. One of the reasons why I have not pursued a prescription on this bill is in discussions with the TMA and other physicians. I don't want to put them in that situation.
And was that a question for legal services?
Yes, if that was correct, that the way that from Public Chapter 380 and what we've done in the past, this is essentially decriminalizing at the state level.
Michelle Fogarty, Legal Services. There is case law that says that states may refuse to use their legislative or administrative resources to enforce federal law. There is United States Supreme Court authority that says that states can refuse to use their own legislative and administrative resources to enforce federal law.
Thank you.
So that's correct.
Okay, any further questions for legal services? Representative Dixie, you're recognized.
I'm not sure if this is appropriate for legal, but maybe she can help me. Just 2 questions. Has any state lost any federal dollars based on medical marijuana? Or has any governor or legislator been taken to court or arrested for passing medical marijuana laws?
Ma'am, you're recognized.
I don't know that. I don't know the answer to that.
Thank you. Thank you, Mr. Chairman.
Representative Lamar, I've come to you previously. I want to make sure, is this a question for legal services? Okay, you're recognized.
My apologies. If I'm not mistaken, in 2001, wasn't there an Robershire and Farr amendment that prohibited the Department of Justice from spending funds to interfere with the implementation of state medical cannabis laws?
I am vaguely familiar with that, but I would have to actually look it up to confirm that that is in fact what it did. I'd have to look that up.
I will leave that up to the chairman if we want to. If not, it's up to the chairman's discretion.
Thank you. Okay, any other questions for legal services? Seeing none, and I have a lengthy list when we go back into session back on the bill. So the parliamentary situation we find ourselves in is when we go back into session, we're going to be back on the bill, and I'm working off of my list that I had before the motion to summer study. Everybody understand? Okay. Back into session. Next on my list is Chairman Farmer. Question has been called on the bill. Any objection? Seeing none. You can make that request. There's a second, a third. Okay. So we have a roll call vote on House Bill 880 as amended. Those in favor vote aye when your name is called. Those opposed vote no when your name is. Representative Hardaway, for what purpose?
Parliamentary inquiry, sir.
Yes,
or
sir.
Inquiry, as my colleague said. Are we voting on the bill or are we voting on the summer study motion?
Thank you, sir, for the clarification. No, the summer study motion was tabled. We are voting on the bill as amended. A roll call vote has been requested. If you are for the bill as amended, you would vote yes. If you are against the bill as amended, you would vote no. Any further questions? Okay, seeing none, Madam Clerk, please call the roll. Take the vote.
Representatives Beck? Campbell? Dixie? Doggett? Farmer? Griffey? Hardaway? Hawk? Howell? Halsey? Lamar? Lamberth? Moody? Russell? Cheryl? Vice Chairman Sexton? Chairman Curcio.
Aye.
Chairman, you have 8 ayes, 9 noes.
Okay, bill fails. Members, seeing no more business before us, thank you for a wonderful year in the Criminal Justice Committee, and we stand adjourned, subject to the call of the chair. Chairman Farmer, you recognized?
Yeah, Mr. Chairman, just want to let you know what an excellent job you've done. You've been a fair chairman. You've done a good job as usual.
Thank you.
I want to let you know. Thank you. Thank you for your leadership. Thank you for your leadership.
Thank you. Vice Chairman Sexton, you recognized?
I would also like to say that you have been an excellent chairman for a vice chairman to work with. And I think one of the most important things that you've done is clean up the mess that come up from the subcommittee.
Thank you.
It's been a joy working with you.
Thank you, sir. Leader Lamberth, you recognized?
Mr. Chairman, I know folks are filled in the room. We're short on time, but I want to thank you for your leadership of this committee. What we have just seen over the last few hours is the courage of a man who I've come to count as a dear friend of mine. And we have disagreed on issues before, but there is never a time in my life that I have ever doubted your heart and your soul to the service of this state. And I admire you, sir, for the way you have run this committee. You certainly have done a much better job than your predecessor did. And I have literally, and I mean this with every fiber of my being, have always been impressed at how you make sure that all of us get a fair shot in here. And that's all of us could ever ask for is that. And Mr. Chairman, thank you for that, because all of our voices have always been heard in here. Thank you.
Thank you. Thank you. And with that, we are adjourned, subject to the call of the chair. All right.
Chairman, I talked enough today, so I'm not going to say anything.
You're good.